Meanwhile, officials of the Nigeria's ruling party, the All Progressive Congress, has been dancing around whether or not police took over its administrative headquarters on Monday, as the party continues to deal with the fallout of its recent nationwide world congresses. Well, joining us now to have a discussion around this is Senator Ita Enang, the Senior Special Assistant to the President on Niger Data Affairs. I want to say thank you very much for joining us on Newsday, Senator. And first of all, what's your own position in terms, or what's the presidency's position in terms of police actually camping at the headquarters of the All Progressive Congress?
Thank you very much. I am not in a position, it will not be appropriate for me to respond to that now because it is not within brief. Thank you very much.
All right.
Okay, well, I just want to ask,
yes,
because I believe you can still offer an opinion, even though we're not asking for an official statement. Mr. Akpanu-Dwehe says there's nothing to worry about, and yet some people might say no smoke without fire. The other side of it is that the response, by having such a large, over 30 police officers responding to a security report, makes people wonder if this does not hearken to the fact that the administrative party or the incumbent party tend to be more concerned about their own security than public security. What do you say to that?
I still plead my privilege not to comment on that. Thank you very much.
What would you like to comment on, sir?
Sorry, I will not want to talk on the security of the party because the persons who are in charge of it have taken action they deem appropriate.
Yeah.
Thank you, sir.
All right, so let's get into the Supreme Court judgment.
I will want to talk with that.
Senator, if you can hear me, let's talk about the Supreme Court judgment that has divided the party right down the middle. Where do you stand in the divide? Do you believe that the acting chairman of the party should step down, or do you think that he's within his rights to continue as the chairman of the party?
Thank you very much. I want to say that prior to now, I'm sure many of you read that I had issued a statement on it, and my statement was that let us retreat and go and study the judgment. And many of the people who commented on that judgment at that time did not read the judgment. I have had the privilege of reading the majority judgment. I've had also the privilege of reading the dissenting judgments. I've read the judgment of the majority judgment and the dissenting judgment, and all of them have agreed that His Excellency, I give him the greatest respect. He has not committed an offense by himself. He was only called upon to serve a situation, Mai Mala Bunu, so we don't have issues with him. We don't even have issues with the committee but it was erroneously implanted. Now, the Supreme Court judgment says that the Mai Mala Bunu, being a serving governor, cannot, earning salary, be a chairman of a ruling party, of a political party, number one. Number two, the constitution of the party and the 1999 constitution have also said that a person who is in any full-time position in any other employment cannot be a chairman of a party. All of them are agreed on that. The only dissenting, all the 7 justices have agreed on that. The only point of divergence between the minority and the majority judgment is the punishment to be meted out. And the punishment is, or the order or the conclusion is, should we annul the election in Ondo State, where Akorodulu was the candidate sponsored by the APC under the signature of Mai Mala Bunu? When Mai Mala Bunu was not joined as a party and it's not heard, they said he cannot. The majority judgment said he cannot. The judgment cannot be given against Ondo State and Akerodolu when Mai Mala Bunu has not been made a party. But the majority judgment has also said that, look, the agent of a disclosed principal, when there is a disclosed principal, as in this case, APC, you cannot say that the agent has to be joined. And so it was not necessary to join Mai Mala Bunu in the case. Therefore, it is certain that, one, Mai Mala Bunu cannot be the chairman of APC. But it is not only His Excellency Mai Mala Buni, it's not only the chairmanship position that is in combat. It is that the entire caretaker committee was erroneously and put in place by, I think, it was an error to be put in place. Because under the law, you cannot have a caretaker committee running a political party. You cannot have a caretaker committee running a political party. The Constitution provides in Section 223, Section 223 of the Constitution, I hope I'm correct, provides that it provides in Section 222 that no association by whatever name called shall function as a political party unless the names and addresses of its national officers are registered with the Independent National Electoral Commission. That is national officers, and these national officers are those elected at a convention. 2. Section 2231 reads, the Constitution and rules of a political party shall provide for the periodical election on a democratic basis of the principal officers and members of the executive committee or other governing body of the political party, and ensure that the members of the executive committee or other governing body of the political reflect the federal character. What we are saying is that under that judgment, they have said that there cannot be, Mai Malubunu cannot. And if Mai Malubunu is this person that signed the signature, that sponsored Akeredolu and the candidates of the APC, that we just simply escape that it is not lawful. But they're saying that they cannot punish Akeredolu for it. So the only difference is the order made. I want to say that when you look at the, I've read the judgment, and I just want to draw attention to the order that was made by His Lordship Agim JSC, Akomaya Agim JSC, who read the majority judgment, which is the judgment of the court. He said, in the light of the foregoing, all the issues raised for determination in the appellant's brief are hereby resolved in favor of the respondents. On the whole, the appeal fails and it lacks any scintillation of merit. Now, that is what the Supreme Court, that is what the majority judgment said.
Okay.
But the minority judgment said, that, let me just, I'll be very brief about this.
Okay.
On page 27 of the judgment, I have the 7 judgments, but I can only refer to the 2 of them. He says on page 27 to 28, His Lordship Ejembi Eko, Justice of the Supreme Court, JSC. Both the lower court and the majority opinion here seems to be ad addendum that the respondent submitted the offensive instrument or letter, Exhibit P21, which is the sponsorship letter, signed by Governor Malubunu, who is expressly prohibited by Section 183 of the Constitution of the Federal Republic of Nigeria from signing this judgment.
Okay.
I mean, from signing the letter. In the concluding part of the judgment, I'll just conclude in a short. They said, Ejembieko JSC said, I allow the appeal since Exhibit 21 is a nullity ab initio. It is not capable of conveying the sponsorship of the 3rd and 4th respondents to INEC as the candidate of the 2nd respondent, that is APC, for the governorship election in Ondo State. Being a nullity, the 3rd and 4th respondents, in my opinion, were not in law candidates at the 10th October 2020 governorship election, and all the votes accredited to them shall accordingly be thrown away, having been wasted. Consistent with the case of APC versus Karfi of 2018 and APC versus Marafa of 2020.
Okay.
The 2 cases in which the 2nd respondent, that is all, involved APCO, where respondent had exhibited rascality, outlawry, and impunity, are hereby ordered the 2nd appellant's candidates, that is APC's candidates, including the 1st appellant, be and are hereby declared winners of the election. That is, PDP was declared winners of the election, having scored the highest majority of lawful votes cast in the election. The appellants had earned the right to be granted in their favor the relief they have sought. That is Jegede SAN. Now, the APC simply and just narrowly escaped. In the case in
Senator
Rivers State, APC lost all because of outlawry conduct. In Bayelsa, APC lost all because of outlawry conduct.
Okay, Senator Enang, you've made your point you've made your point actually, and I appreciate that you've gone to such detail. I just want to ask, just to direct the conversation, you say that people who are commenting and saying that the judgment doesn't have any impact on the way the APC should be moving forward, that they haven't read the full judgment. But by now, you would think that most people would have read the judgment before coming out in public to offer an opinion. So that's on the one side. On the second side, even the things you mentioned didn't necessarily need a judgment to point them out with regards to Section 222 and 223 and the Caretaker Committee. So why the discord? That's what I'm asking. And what are the consequences if people continue to, in a way, dismiss the significance of this judgment going forward?
The significance is going to be very dangerous for the party going forward, because even if we are to file presidential candidate in election, we can, and under the present executive, we do not have an executive known to law that could file a candidate for the election. All the 7 justices agreed that APC, as it is today, cannot exist as a political party because it does not have democratically elected executives of the party. Now, what happened? It is that there is in existence elected officers of the party, which was led by His Excellency Adams Oshomole. Adams Oshomole, His Excellency, had resigned. Now, the constitution of the party has provided how there should be a succession. If Adams Oshomole has resigned, there is a second person, there is a third person, there is a fourth person in order of ranks. Those are the persons who will take up the office. But on no account should any officer of any office in the party be run by an ad hoc or appointed caretaker committee or any person. Again, I have heard persons argue, in particular the members of the caretaker committee and those who support them. At my stage, it has taken me much to decide to come out to speak again on this matter. Now, some persons have said, look, the party can set up a committee. Yes, the party can set up a committee, but the party in itself cannot become the committee. The party can set a committee to conduct election, to screen candidates, to go and conduct congresses, conventions, to go and nominate people, to go and investigate particular issues, to conduct convention. But the party itself cannot become a committee. I will read Article 18 of the Constitution of the APC, which is what they quote as authorizing them to set up committees. I read very briefly. He said the National Executive Committee shall have power to set up standing committees and, where necessary, ad hoc committees. And the standing committees, only 2 standing committees can be set up. Committee on Finance and then Publicity Committee. The ad hoc committees that can be set up are also stated: screening/selection committees at the state and local government and at the federal level. But it prohibits the party from setting up committee. Let me take you to an analogy in the Constitution. Section 62 of the Constitution.
Go ahead, Senator Enang. We're listening.
Allows... Yes, sir.
Go ahead.
I'll just conclude. Now, Section 62 of the Constitution allows the National Assembly or the Senate and the House of Representatives, and a corollary section in other parts of the Constitution allows the House of Assembly and even the Legislative Council in the local government to set up committees. But it has prohibited that committee from delegating or assigning to it the job that the entire legislature is allowed to do. It is the same thing that the Section 18 of the Constitution of APC is saying, that Section 6 is saying about the running of the party, that Section 62, subsection 1 and subsection 4 are saying about the running of the legislature. Please, I'll read it briefly. It says, the Senate or the House of Representatives may appoint a committee of its members for such special or general purposes, and it has also stated here.
All right. All right,
as
Senator.
in its opinion, would be better regulated and managed by this. And it has says, nothing in this section shall be construed as authorizing such a house to delegate to a committee the power to decide whether a bill shall be passed into law or to determine any matter which it is empowered to determine by resolution under the provisions of this constitution, but the committee may be authorized to make recommendations to the House on any such matter. This is a corollary of the provision of Section 18 of the Constitution. Therefore, it is not just the Mai Malabunu, His Excellency, office that is unlawful. It is the entire contraption. So my proposal here is that we should swallow the bitter pill.
All right, I want to say many thanks.
Swallow the bitter pill.
All right.
Take the bumble pie and call back and recall the suspended national executive and give them a month or 2 or 3 to conduct national convention. Because even a national convention that could be conducted by this body will still be declared illegal because these persons have no power or authority to do anything that is known to law on behalf of the party.
For availing yourself to this interview, talking about Senator Ita Enang, the presidential aide to the president on Niger Delta affairs. I want to say thank you for joining us here on Newsday.